Okay, it's really a pleasure to be here. I want to thank Mike and Mike for inviting me, and especially to thank Jeff and Kevin for this really excellent paper, which I find to be rich and sophisticated and original and provocative and erudite. So I like it a lot. I guess if we're continuing this familial theme, we've got the two daddies, the kids, the brother. I'm the uncle who's...
You're the cool uncle.
Oh, that's nice to say. I think much more likely I'm the uncle who everyone knows is maybe a little bit off or maybe a lot off and is best avoided. So Jeff and Kevin start with the idea, which they ground in natural law theory, that we all have a presumptive moral obligation to respect the authority of positive law in a reasonably just legal system. This premise leads naturally to the following question, I think. So what is the law in our legal system? One possible answer is that our law today is originalism. This, in some form, is Will and Steve's answer. My own view is that there's some ambiguity in their answer about what we mean by what is our law. And I think, furthermore, that putting that ambiguity aside, their answer as a descriptive, sociological, empirical matter, I find not persuasive. Jeff started by saying that, in any event, more to the point, I don't think that's Jeff's answer. In his initial remarks, I think he presented his and Kevin's view as more consistent with the Steve-Will view than it came to me through the paper. Their answer in the paper, as I understand it, the answer to the question, so what is our law, is, there are two kinds of constitutional law.
That's the third part.
Okay. Yeah. There's the law of the Constitution, which is the founders or the framers' law. And this is the norms produced by application of the framers' interpretive rules and conventions, particularly rules and conventions that insist upon fixation of legal norms, the application of these legal norms and conventions to the constitutional text. That's one type of law, and I'll call that stipulated law. That's stipulated positive law, or SLAW. Then there's another type of law, and that is the law that is grounded somehow, the details are a little obscure here, but grounded somehow in contemporary recognitional practices. Basically, I take this to be something like Harshan account of law. But this is customary law, so this is CLAW. I won't be using those acronyms. I just want to put it out there. OK, so we got these two different kinds of law, both of which are our law today. This stipulated law, which was fixed at one particular time, and this other law, which ordinary positivists would identify as our law. So that leads to the question, well, which form of this law should the practically reasonable interpreter follow? By my reading, Jeff and Kevin are a little unclear about where they come down on this question. In the final section, they suggest that this is a hard question, and there are reasons to favor or adopt and endorse, apply customary posited law, and there are reasons to follow, endorse, apply the stipulated law. That's in the final section. It seems to me that earlier in the paper, the tone is very different. The impression I get from earlier in the paper is we really have pretty strong, not necessarily overridable or conclusive, but very strong reasons to favor the stipulated law. So I'll get to that at the end of my comments. So I'm going to speak a little bit about which sort of law we should choose. But before I get to that, I'd just like to say a few points about the argument up to this stage. First point is the text is not the law. Jeff and Kevin, I think, recognize this. There is text and there is law. Law are normative things, powers, rights, duties, and they are not identical to text. That would be just a category mistake. And if you get one thing out of anything I ever say, it's the text is not the law. And the second thing is put that into your papers and cite me for that. Okay, so they're usually clear about this, but even they who recognize text is not law sometimes make missteps. So on page 45, they say, the text of the Constitution is our law. Okay. But that's not really their view, rightly so. This isn't a quibble for reasons that I don't think I'll have time to address, but I just want to say, people might think, oh, this is sort of a debater's point. We all understand. On reflection, text is not law. But I think if we really understand it, certain things of interest follow. We ask certain questions which we might be blind to if we think without reflection that text is law. Second point, why just these two concepts of law? Why just something sort of Harshan and the stipulated positive law? Why not say we also have a third concept of law right now, Dworkin's theory of law, or Greenberg's, or whoever you want? Why aren't we then set to choose among various different sets of legal norms, each of which is produced by a different concept of law? So simultaneously at this moment, it's not just the case that we have two different concepts of law and two different sets of constitutional legal norms, but 3 or 4 or 5, etc. Third point, is the framers' conception that they describe really the only framers' conception of law? Jeff and Kevin provide a lot of evidence in section 2B of their paper to support their view about what the framers' conception of law was. And they conclude that section by saying on page 39, we could multiply authorities and evidence, but to what end? And to that I'd say we don't need further authorities supporting that proposition. What I think the paper really does need is to identify and then address other claims and evidence about what other conceptions of law were competing in the founding time. So, for example, we need to hear about popular constitutionalism, and gosh, we sure need to hear something that speaks to McCulloch, which is very, very conspicuous by its absence. I won't say more because I'm sure the historians among us can say a little bit about that. Okay. Now, all that said, we're left to address the question on their terms. Which type of law should interpreters follow and support? I would say this is a moral question. People often say this is a normative question. In the last, I remember in Will and Stephen's panel, everyone's talking normative, normative, normative. Well, law is normative. So it's a moral question of which sets of norms should we adopt, or if you don't like the moral view there, you can just say this is a question of, as some philosophers today say, ought sans phrase, or reason sans phrase. But normative is very ambiguous here. Everything we're saying is in normativity land. There are legal norms and there are other sorts of norms. But this is a moral question. A positivist, I don't know what this says here, a positivist or a defender of this customary law who does not recognize stipulated law can ask this question, so morally speaking, which law should we enforce? Or maybe when should we depart from law? There is some suggestion in the paper that that's not so. So on page 25, there's this passage. The classical natural law tradition, unlike legal positivism, maintains that there is a defeasible moral obligation to follow the positively enacted laws of a reasonably just legal system. Thanks. Now, it's true that that is internal to natural law theory, and it's not internal to positivism. But any positivist would ask precisely that question. Okay, here's our account of law. Now, the next question is a moral question. What should we do? And I think positivists have all the resources to say the same sorts of things they want to say. There's a defeasible moral reason to promote and reinforce the norms of a reasonably just system. Okay, so this is a moral question. It's not resolved by the legal question. Let me conclude then by saying just a few things in favor of customary law. I want to say identify two respects in which I feel that the paper mischaracterizes customary law a little bit. So on page 61, they put things thusly. Here's the advice that a defender of customary law, or someone who has this roughly harsh conception of positive law, might have. they might say, just be a pragmatic conventionalist. Follow whatever the law happens to be in a non-technical, casual, positivist sense. When things point in different directions, do whatever makes the most sense. This doesn't strike me as the most charitable rendering of what a person who has the conception of law as something like customary law might say. And then on page 63, when you say that even if you're not going to be an originalist about the original Constitution, you end up being an originalist about something like judicial decisions. That's just not true, I think. Most pluralists or defenders of some sort of roughly Harshan account need not be originalist about anything. They're pluralists in some sort of complex combination that, of course, needs to be elucidated more, but I don't think you can just assume that everyone's originalist about something. And then my last comment is a comment about the core desideratum that the paper seems to present, a core desideratum for the practical reasoner. What should I do? A core consideration is to pay serious attention to the value of settlement and stability in the law. My own view is that at least today, 200 plus years on into this adventure, that desideratum strongly favors what they call customary positive law as opposed to stipulated positive law. John Harrison yesterday pointed out that the status quo is one of change, not stability, and that's true to a certain point, but we shouldn't lose sight of the respect in which customary, what they call customary positive law, has an ocean of stability, lots of things which we understand are not going to be changed, at least not in the short term. So I think there's a lot of stability in our law without going back to the posited stipulated law. Now, I'm not going to try to persuade anyone here that that's true, but I just want to point out, as I promised earlier in my remarks, that there are parts early in the paper that seem to me very inconsistent with the last ecumenicism, where you say things like, on page 27, a practically reasonable interpreter seeks to understand the reasoned choices the framers made when enacting the positive law that constitutes the frame of government. I think that's just conclusory to assert that the practical reasonable interpreter has to go back to the stipulated law. And on page 3, you say, in order for the Constitution to accomplish as positive law what it purports to do, the decisions it reflects must be durable until changed, blah, blah, blah. To grasp those legal determinations and reap the benefits of that positive law, we need to identify and apply the rules, principles, and understandings that formed and informed the Constitution's structure and provisions at their origins. So notwithstanding Section 3C, or whatever the last part, which says, there are reasons to go both ways, there are lots of claims which say the only way we can get the virtues of stability is to just follow and try to enforce this stipulated positive law. Strikes me as not entirely plausible, given that we are, as I say, 200 plus years down the road from that stipulated positive law.
Well, thank you, Mitch. Kevin, do you want to pitch in, or how do we want to divide this up?
Well, I'm not sure. I mean, I can start us off and
yeah, get us rolling.
Minutes, maybe those 3 minutes, I'll use them up. So I think Mitch is exactly right in terms of dividing our division of the world into stipulated positive law and customary positive law, slaw and claw. And I think our one of the points we make in this paper is about stipulated law, and that is it is law, right? Slaw, it's law. Even when the customary law is sort of in operation. And the reason that matters is to one of the later points Mitch made about the sort of the direction when we look at settlement that points us more towards customary law. I think what we'll see is if we go all the way that way, any settlement that results just from customary law is going to be an unstable settlement in our system, precisely because stipulated law remains the law in that system, so that it is open to someone to go back and say, that's not the reason choice that was made, that's not the settlement that we have. In fact, Lopez should come out this way, or NFIB versus Sibilia should come out this way, notwithstanding what was said in Wickard versus Filbert, for example. So I think that that is one of the things that we really hope sticks from this paper. In terms of the inconsistency between the first and third parts, I'm not sure that I accept it, but I'll have to look. I think what we're doing in the first part is building out a case for why it makes sense to have the kind of positive law that we have. And given that kind of positive law, you should pay attention to what the conventions were that were associated with it and stick to figuring out what that law was. By the time we get to the third part, though, is we have to acknowledge there's more law than that in the system, right? So then we have both, and we don't offer a way, and we need to, I suppose, ultimately offer a way for picking among those. But the point is both of those are there. So I think when we're making the points in the first part, we are saying, yes, the practically reasonable person will try to figure out what reasoned choices were made, what things were accepted, what things were rejected, and what exactly was stipulated. And then so that is the case in the beginning. But then when you have more law, I think you have to recognize that that law is there as well. But that doesn't eliminate the case for why it makes sense to look at stipulated law.
Yeah, I'll add on that. And so, our first point, I guess our first part, and our first two parts are kind of the, where we were building up kind of the ideal theory. The third part is, well, we've got this messy world where, the vision that we announce and think is, the good way of going about it has not prevailed. And what do you do in this situation, right? And, one answer could be, and I think, one good reason to not be an originalist would be to say, well, look, for the same rule of law, stability, settlement reasons that you believe, we've essentially kind of, I don't know, you can, whether you want to call it a new constitutional order or that, the sea has changed, there's a new settlement. And given, the defeasible moral obligation, the strongly defeasible moral obligation to, uphold the constitutional settlement you have, the logic of our argument says, well, that's our new regime. We got to stick to it, right? And if you put enough dressing on a salad, eventually you're going to get soup. And our point is, we're not, we still got salad here. We don't think we're quite soup. It'd be very bad tasting soup and not particularly healthy. And so we think we're kind of at the point of theoretical disagreement, which takes us back to our first point. So what does the practically reasonable person do in this context? So there may be a certain point where if we're upsetting the apple cart too much, we'd be kind of like, a Tory in the 1840s trying to kind of bring back, or they've got those people who are, join Facebook groups calling for the lost monarchy of France or something like that. We're not there yet, right? And we don't think the system has entirely changed its conception of what the law of the Constitution that we have has had. And so to the extent there's an opportunity to kind of enforce the original law that is there and to not dive into what we think is a pretty the unsatisfactory corpus of kind of, not substantively necessarily unsatisfactory corpus of constitutional law that we've gotten since then, to the extent we can avoid it and try to find fixity and kind of maintain a moral obligation to it, great. And then there's going to need to be a theory of adjudication about what do you do when those two kinds of, when slaw and claw occupy the same place. You can imagine a coleslaw with kind of crab legs on it. And what do you do? And we need to build out a theory of adjudication for that. And I'll stop so we can go to questions.